everyone, it's Gayani. I wanted to do another video on contracts, and I just did one on 5 cents not to commit with a contract, and this is kind of looping in some other things that you want to think about with a contract. If you are doing a partnership or creating some kind of a consulting agreement, you want to make sure what's happened with the intellectual property and confidentiality of the information. Let's say you are the person who have the invention idea, and you're consulting with another technical specialist developing the idea. You want to make sure that in the contract that you have provisions that say that they will assign over those rights to you, and they will work with you while you are going to the patent prosecution process or whatever. Because during patent prosecution, you have sometimes you need the inventors to keep signing documents or give more information, and you want them to be available for that. So again, this is just a disclaimer, by the way, that this is for educational purposes only. I am an attorney, so I had to put that in. And if you want to connect with me, my information is below. And if you have a specific question, please connect with the attorney for that area. So another thing to think about contracts is about fairness. So you cannot have in a contract that is something punitive, meaning trying to punish them for if something goes wrong. So make sure that if you have a provision on damages, or if there's a breach, how you seek the damages, meaning what you get to recover, is calculated in a fair way. You can do it where it's a more of a punishment that they do it, but more about calculating what is your losses could be based on some formula. So there are actual specialists who do these kind of calculations, where they look at, like, if it's a sales thing, and if you're developing a product and the other company doesn't provide you the product on time, how many, like, if you are without your product for a month, you could lose sales up to a month, so you could get that back. So that's another thing to think about with the contract. With the contract also, you want to make sure that you have the information that is like confidential information, those information in a more prominent place. So if you have a 10-page contract, you don't want to bury the most important things for you for that contract in the middle. You want to put it somewhere that is visible, and make sure the other party understand where that is. So you also want to have in a contract what happens in a case of a breach. If you could get a equitable remedy, if you could get an injunction, what's going to happen, all of that information. You also in the contracts will have what is the jurisdiction that are going to apply to that contract, the governing law. So if you are a business in California, you could actually put it that is the California law that apply, even though the other party is in a different state. So that's something to think about. You could also in a contract put that if there are certain things that you're not sure that gonna get updated, like the scope of the work, you could put it as a exhibit that could be updated, so you don't have to get a new contract each time. But with the contract, remember, both parties had to understand what's in there, so you don't want to leave it where it's ambiguous, because the contracts should be straightforward and in plain language. So those are a few more things to think about with contracts, and I hope that helps with your business or whatever you're thinking. And if you like this video, please give it a thumbs up and subscribe to my channel, and I will see you next time. Thank you.